evening. I, Molikasha, bid a very warm welcome to the speaker and participants who took out their valuable time and joined us today to be a part of this webinar. We are honored to have you all. We would also like to offer my regards on behalf of Pragyan Foundation, promoter of Pragyan International University in association with the Global Academy and Lions Club of Kolkata, Harmony. Just a little housekeeping before we get started. If you have any queries during the presentation, please type them into the chat box. And to keep the quality of sound functional, please mute yourself. At the end of the webinar, we will share the feedback form link. Today's theme is an invention into document. Importance of patent drafting. Patents are important because they help inventors protect their inventions, products, or designs from being copied and stolen by others for a limited period of time, usually for 15 or 20 years, depending on the type of patent. Patent drafting is probably the most important aspect of the patent application. Intellectual property right provides the applicant with the right of excluding others from using the same invention. But this is dependent upon the fact of how the claims are drafted, thereby making the drafting process the most important one. To provide an answer to our curious listeners, definitely we need an expert who can guide us. We are really exhilarated to have our guest speaker, dignified personality, Dr. A. Selvaraj from the Manchester of South India, Coimbatore. Dr. A. Selvaraj is an associate professor and head Department of Geoinformatics Engineering, Park College of Engineering and Technology, Coimbatore. Without further ado, may I now request Dr. A. Selvaraj for giving your valuable insights on an invention into document, importance of patent drafting. Please, sir, and unmute yourself.
Yes, it will.
Yes, sir.
Okay, ma'am. Thanks for nice introductions, Mrs. Mauli Kalsa. So, very good morning to all. Good evening to all, and welcome to the presentation on an invention in the document and importance of patent drafting. So, when you talk about that intellectual property, it's like a very significant role in today technologies. As just now introduced by Mrs. Kalsa, she said some important things of patent process. Really, I'm going to say like intellectual property always played an increasingly significant role in today technology. Yes, definitely, every one of us we can agree with it. When we talk about the patent, or the patent are very asset for any organization, especially for our academically, any faculty, okay, any faculty wanted to have the patent. So because so then only any organizations will be recognized, okay, will be recognized of any faculty with the patent. So such a very important curriculum activities, and also I can say the like very strength of an organization, which can be measured through the patent activities. And also, when we talk about the pattern, it is long process, definitely. So we have the time. We should have the time. We can wait for long time also sometimes based on our invention. But minimum 1 year to 3 years. So mostly in minimum time maybe depending upon our invention maybe 6 months minimum. So 6 months to maximum 3 to 4 years, even sometimes 4 to 5 years. It's like a publication also, like scientific publication also. Sometimes based on your inventions, it takes time. So I can say it is a long process. And also because we want to some evaluator wanted to check the novelty and non-obviousness. So non-obvious sense, your invention, your idea should be non-obvious. And also it can be industrial applicability of the invention. So these three things are very important. Wait a second, please. Yeah. So here, when you talk about the patent, right, it involves like novelty, non-obviousness, and industrial applicability of the invention. So in these three aspects, we got to draw your invention or able to construct your invention. And also a patent granted by the government gives an exclusively right to an inventor. Inventor means what? Basically, any natural person. For example, I'm going to find some inventions which is to be patentable. So I'm the inventor. The inventor makes some inventions. So when we talk about this kind of inventions, normally limited period of 20 years. On today, it will be the invention should be protected for 20 years by me. So after 20 years, our idea, our invention, or my invention maybe vanishes. So this is very important. So we can protect our inventions for 20 years. It's very, very important. And the fundamental idea is to be safeguard our invention. So this is what main important thing that. So safeguard our invention. So we have some Indian government set up some patent office. So by using the patent office, I can apply for some patent inventions if you find something or if I find something. So I can send my inventions in terms of document to them. After that, it can be maybe patentable. So based on the particular reviewer or particular when we talk about the controller, normally in patent office they are having like controller, like reviewer in scientific journal. No? So like this in patent office, yeah, the patent office has some controller. The controller may be reviewing your invention. So it's a very important. These three things are very, very important. Keep in your mind that. And normally when we go for, as I said before, the novelty is very important and non-obviousness. Okay. Suppose if idea already obvious, so cannot be patentable. So keep in mind that I'm repeating again. If you find something, the finding is maybe obvious, so we cannot make patentable. So what I'm saying is that where patent is non-obvious, where patent to be non-obvious invention. It's very, very important. And finally, as I said before, we can go for some commercial. For example, I found some product in terms of, for example, I'm going to find something in terms of some machines or some product, some accessories, okay, to be fitted into some machines. Okay, so it is to be like industrial applications. So we can go for commercial. Even so if I'm going for interview with patent, the particular person may be asking that whether you go for commercial, whether you can go for whether you are going to sell your product or not. So such a very, very important thing that so a great weightage for us. Okay, so that we can go for industrial application. Our findings should be applicable for industrials. So these are process to be get patent. Normally you can go for step by step. As I said before that, it takes time. So keep in mind that it takes 1 year to 3 years. If I want to go for patentable, if I want to get patent, okay, so you would wait for some time. So publication is not a matter. I'm telling you, okay, how you are going to publish your patent. Okay, so I'm telling you, wait in the coming slide. In this slide, you can see there are various steps are available. Okay, like step 1 is go for patent application, and like patent examination, then response, and finally patent grant. According to the patent attorney Jamsan. So this is a prerequisite for patent applications. We should have some form, and we can have some fees applications also. We can give some for different form may be there. Some form may be applicable for fees. Some form may not be it's applicable for fee. Okay, some form may be at free of cost also. And detailed written description. So these are the prerequisites for patent application. And when you go for important forms, so these are the forms are available in patent office like this, form 1 and form 2, form 3. And these are the forms are mandatory to us. So when we talk about form 1, always we go for application for patent application. Okay, form 1 may be applicable for patent applications. Okay, and the form number 2, it's filing the complete specification. So this is what I'm going to for particular talk. My particular talk on this topic one. Okay, how to go for specification. And form number 3 is statement of undertaking, and form number 5 declaration of inventorship, and form number 9 is a request for early publication, and form number 18 request for early examination after 18 months of publication, and form number 18A on request for expedited examination. So when we go for form number 18A, so it tells us on request for expedited examination. Okay, so which means we can apply this kind of form through only internet only. We can apply the form either in offline or online, but when we come across this form number 18A, we can apply through only the online. So keep in mind that. And these are the notable patent office database. For example, there are several database available, but even sometimes you can go for commercial database available in globally. But these are the very important notable patent office like database. They are having like a published database. For example, when we talk about Google patent, right? The Google patent has the patent from the Canada and from the China, and the patent publication of European countries, Germany, and city means like international application. See, again, I'm telling that in mind that there is no any classification like international patent. There is no such classification international patent. Don't tell like that. Like having like international publications, international patent. It's not like that. Only you should have only national publication, national patent only. For example, I'm in India. I'm applying for my patent. So these are national application. My product wanted to be developed in China. So I can make use of my patent invention to be patentable in China. So this is what we can say national. Okay, so there is no any international patent in that. Okay, so when we come across notable patent office database, when you go for Google patent, it has n number of patents already published patent. So like literature review, scientifically, when you go for publication of in scientific, right? Some scientific publications, we are having like literature reviews, like journals. So like journal here, like some database like Google patents, and these are the Google patents portal. Okay, we are having some website search. Okay, by making use of some keywords here, we can search some patent, published patents, or even sometimes grant patent also may be possible here. Okay, and East FaceNet, it's a very largest among the patent office of database, right? It has 100 millions of patent documents from 90 countries. And similarly, for particularly United States, right, it has some database like USPTO. It contains more than 10 million patents from 1792% at present. So almost 5 million published applications from 21 forward. So both databases are updated weekly. So weekly, they're updated that pattern. For example, today I'm going to apply with pattern in US pattern office. So next week they may be updated my pattern invention if I published. If my patents in patent publication is published today, so within the next week it may be updated in this kind of database. So I can say all the notable patent mentioned here are the open source. So no need to pay the commercial. I mean, not to pay for anything. But when we go for commercials, it's very costly. It involves costly. Like in Indian rupee, I can say more than 3 lakh you have to pay. So don't go for that. So only you can go for only open source database. And these are the overall steps involved in this, involved in the kind of patent process. Normally, you have to apply your applications once you find the invention. Okay, always you have to find your invention. For example, today in my mind, I think something about something, isn't it? For example, in my mind, when we talk about some machines, okay, in my mind, I can think, why do I want to make something change on this particular machine? Can we do something on this machine? Can we apply my mind in particular machine, or particular product, or particular thing, or particular theory, or particular process, or particular method, whatever? Okay, but only one thing that you got to think of. Once you think on your mind, once something happen in your mind, immediately you can expose into document, because we do not know when we are thinking like that, when we are finding something. I mean, when we are going to find the time for thinking as such, right? So you make some time to think about something. Once you find something, you can convert it into the document. So that is a very much important. Once you keep in the document, you can go for patent aspect. So don't bother about that whether it will be patentable or not. So don't think that. First, you try to think on particular theory or particular method or particular process. So then go for patent search drafting. So like literature review, I said, right, you can go for searching the document. Similar your invention. I find something today. I'm going to find some new product. Okay, so regarding this, I want to search out. Okay, I want to search it out whether the kind of invention has been published already. Okay, so as I said before that, by make use of this database, okay, by using this make use of this software, I mean this kind of database. Okay, it is a portal, like a software packages. So by using this, you can search the pattern search drafting, so that you can get some idea, okay, whether it will be a new one or it is existing one. So accordingly, you can do your invention, right? So after then this kind of patents drafting, you can go for filing the patent application. So this is what my main talk about it today, right? Filing the patent application. So after that, once the filing the patent application, so definitely your publication to be published in patent office. So here again, I put like publication of the patent. It's not like that. So don't do like that. It is your publications of patent draft only. Somebody may be saying that I have the patent, 2 patent, 3 patent, 4 patent. Okay, so only they have the publication. Okay, patent land is the second stage. It's a very important stage. But however, nowadays most of the universities and most of these organizations, they recognize for patent publication also. Still, as of now, any like government organizations, right? They are not giving any guidance for us. In future, maybe implemented like publication, like 2 to 3 publications should be in the SCA or SCA, right? Like this, you should have like minimum 2 to 3 patent publication in your academic area. It's very important. In future, maybe implemented. So now itself, this is the right time to, after presentation of this, we will be able to understand what is the patent and how we are going to use that. So within next 2 years, we have the patent. Okay, so I hope this will be very input for you. Okay, so after publication patent, we go for request for examinations. So this first stage of it, right? Publication stage. After publication stage, we go for patent grant stage. It's a very critical stage also. Sometimes it may not be mandatory to us. Okay, some maybe wanted to only the publication stage. Okay, somebody wanted to have both publication stage and patent grant stage. So when we come across patent grant stage, we are having like request for examinations and respond to the objections and grant a patent. So this is a final stage. And also here, when we go for this time space, also very important. Right? Here I'm mentioning this is some time space from the source of this. And here, once the filing the document, you have to wait for 18 months. In conventional times of publication of the patent, we should wait for 18 months of getting the publications. Okay, I'm telling you, if you want to go for fastening the publications, I'm telling you, wait. So, okay, once the filing the applications, you have to wait for 18 months for publications. Okay, after that, it will go for request for examination. However, unless request for examination is given by any applicant or any inventor, so they won't take your patent draft for examination. So we have to apply, basically meaning that we have to apply for request examination. Unless request for examination is not given by you, so they won't take your patent draft for further process. So very important is, okay, we can apply for apply for form number one for invention for patentable. Next we can apply for request for examination. Okay, so after maybe after 48 months, right, they will be giving like first examination reports. First examination report to be given. So which is nothing but FER. Okay, FER. So first examination report. So then we can go for examination report reply should be given by the inventor. Then like filing process, filing responses to be done. So after that, the controller may be reviewing your or evaluating your patent draft. Then we give for grant. And also when we go for patent process, sometimes free grant oppositions and as well as post grant opposition will be taking place, which means somebody maybe can apply for free grant opposition. Okay, because of patent infringement. Somebody took my concept sometime. Okay, somebody maybe extracted my concept. They are trying to go for patent. So this is what basically we can say. Technically, we can say patent infringement. Okay, patent infringement. So this is a very important thing. So we can apply for free grant opposition, and we can apply for post grant opposition. Free grant opposition means you got to apply once the publication done, once the your invention to be published. Okay, so I can apply for free grant opposition. No, okay, so that is my invention. Okay, so I request controller. Repeating, I request controller that is my invention. So here I'm applying for free grant opposition. So when we talk about patent in India, we having act like that, Indian Patent Act 1970. Indian Patent Act 1970. It has some section, it has some form, it has some rules already. Accordingly, you got to be done. Okay, accordingly, you got to we can work on particular something, particular things. Okay, so basically, we should know what are the rules are there, what are the section are there, and what are the fundamental forms are needed for our patent. So these are all you have to go through in the website, in official website in Indian patent. Okay, so in the flow chart, I summarize like that. You can filing the patent, then you can go for first examination report. Then you can give the response for first examination reports. Then the controller may be taking the decisions whether it will be taken for grant stage or not. If it is grant, they will go for grant or refuse. And there are two important intermediate like free grant oppositions and post grant opposition. Post grant opposite means what? Once the grant given by the controller, okay, by the time if I come to that is my invention, I can go for post grant opposition. I can go for opposing that grant. Okay, so in terms of applications, so whatever we want to do interact with the patent office, okay, we are having like set of or some protocol like in terms of forms. Okay, you can interact with only the forms. Okay, so you have to go through with, there are up to 30 forms. Okay, from the form number 1 to 30 forms are there. Okay, you can go through all the form number 1, form number 2, what it is selected. Okay, so that is important. And when you apply for your patent, the first step is that you can go for applications. Consumer application means what? The inventor who wants to go ahead with your invention. The invention, you should have some inventions like product or like process. Once you find some process or product, right, you can go with applications. So, and another thing that the inventor must think through what is the field of invention. Okay, what is the field? Whether it will be like biomedical field, whether it will be like mechanical, whether it will be like communication field. So whether it will be like belongs to like we can say like a computer science, like science or art. Okay, so the mathematics, sometimes geography or physics or chemistry. So I got to think it out that what are the uh, field are there. Okay, your invention is belongs to or your invention fall into which category. So that's very important. And simultaneously, you have to think on what are the advantages also. Okay, what is advantages? Suppose if your product, okay, want to be make as a commercial, what will be like advantages? What will be like disadvantages? And how it will be improving already existing solution. So this is another important thing there. Okay, so we cannot go for new things. Sometimes we can go for modification of already existing one also. Okay, when we go for modification, okay, your invention should be giving proper solution or proper answer for existing solution. So very important. So under section 3, from we are having like some provisions from A to O. Okay, so it tells us that some important things about your inventions. For example, when you go for section number 3, under 3F, right, it will be mentioning that the mere arrangements or rearrangements of or duplication of known devices, each functioning independently of one another in known way. It's a very important thing there. Okay, even I got this kind of comment from controller in my invention, which means basically if you find some new devices, okay, so that devices may be modified devices or mere arrangements according to that controller. It may be like new to you, but according to the controller or my point of view, your invention may be mere arrangement or rearrangements or duplication of known devices. For example, IoT based devices, or you have modified some refrigerator, you modified some electrical machines or electronic machine. So basically what we do is we are doing some designing of some machines or some product, right? So in terms of controller point of view, it will be like mere arrangements. And also when we go for H, right, under the section of 3H, right, a method of agriculture or horticulture may not be patentable. If you have any mathematical equations or having equation like A equal to H plus C, cannot be mathematical. Okay, so any mathematical equations cannot be patentable. And also if you go for like computer program also, so cannot be patentable. Okay, so you can go through is all the A to O, and the topography of the integrated circuits under O, and a presentation of some informations, or even if you go for any biomaterial like plant and animals, okay, then you can go for some natural laws also there, right? Natural laws. The invention which is frivolous, of which claims anything ambiguously contrary to well-established natural law. So that is also not patentable. Okay, so you got to check it up whether your invention belongs to this category. Okay, we check it up before filling these applications. So now I come to the particular talk like patent search and drafting, right? So after getting clarity over inventions, the inventor must do the patentable search. So by using the database, existing database or commercial software, whatever, you can make use of that particular inventions into that portal. We can check it up. Okay, like literature survey. So after that, we can come to that whether the inventions is novel or not. All the inventions must meet novelty criteria under the Patent Act. So very important thing that. So after that, the patentability opinion or inventions can be examined upon conducting an extensive search and forming the patentable report. We should have some report based on our inventions. For example, in our report, you should have some objectives, you should have some process or methodologies, or what are the equipments you are going to use it, whether it will be like experimental based work or non-experimental based work. So we should have some patent report, I mean patentability report. Okay. So it is not mandatory, but sometimes it is mandatory if we go for other national country. I said before that there is no unique classification like international patent, other national patent only. I'm going to apply with my patent in US. So by the time the patentability report based on our invention is necessary. So this is what basically I'm stressing you that. So next step is which is follow is effective drafting of the patent applications. Your application should consist of like claims, background, descriptions, and drawing, abstract, and summary. So as I said before that, after 18 months, your publication, your invention to be published. Sometimes, in case the applicant does not want to wait till the expiry of 18 months, we can go for the patent application is published within 1 month from the request of early publications. So you have to fill your form number 9. You have to file your form number 9 with patent office. So this is very important. And the patent office publish all the patent application in official patent journal. If you want to execute the publication process, you need to submit form number 9. So after that, you have to apply for request for examinations. So unlike the publication, the examination is not automatic process. Already I said, right? You have to apply it. You have to apply for request for examination. Okay. So normally, the request must be filed within 48 months from the pattern of the filling of the applications under the form number 18. So once a request is given, the controller gives the application to the patent examiner, who examines it different patentability criteria. So which are novelty, non-ambiguousness, or inventive steps, and capable of industrial applicability. So these are the parameter the controller keep in mind that. And finally, once you receive the FER, that is first examination report, the inventor should respond to the objections. I am telling you that what are the, I will be showing that document, first examination report. I will be showing that publication also. Okay, I am showing that, wait. Okay, so how to respond to the objections? You can go through that, all the objections. And the applicant will provide the patentability of the invention and try negating that entire objection being raised. We can compromise all those things. Okay, so what are the claim? What are the objections they given? We would read out all the objections, and we would check it out. What are the objection and how we are going to answer of that objection? So we can go for compromise that controller. So this is my method. I have this kind of invention. In particular pattern, it's not like that. They have used this kind of method. I'm not doing that. In my work, these are the things are unique in me. These are the things are very new to me. Particular kind of inventor does not follow this kind of that my invention. So there are different dates. So like this, we can go for that respond to the objection. So this is a very crucial stage. We should have some experience there, because we have the time. Okay, we have the time for minimum 6 months. Even sometime we can go for extension of the time for 3 months. Okay, so within 9 months, I can go for a response of that particular process. I can filing that first examination report, reply process. Okay, I can take 9 months. So don't go for yearly. You can go for compromise that, because my ultimate aim to get patent. Okay, so that we spent maximum 3 to 4 months. Okay, accordingly, you can follow the objections and find the answer for objection. You can interact with controller, compromise them. Definitely, we can get patent. So this is a very important stage that. So finally, you can go for the grant of the patent. Okay, after addressing all the objections, the application would be placed for grant once it's going to be meeting all patentability requirements according to the Patent Act, or sometime amendment also. Recently they made amendment, even sometimes you can go for Patent Act and 2003 also. Even 2022 also they modified something, amendment something. Even the fees is reduced, 80% of the fees is reduced for organization. Okay, so same fees for natural persons for organization also. 1,600 for natural, 1,600 for any organization like college, like university. 80% of the amount is reduced. Okay, so these are the amendment. So we can, okay, what's happening on the Indian Patent Act, very important. Okay, so after addressing all the objections, right, application will be placed for a grant once it is found to be meeting all patentability requirements, and finally the patent will be granted to the applicant. And the grant of patent is notified in the patent journal, which is published from time to time. Okay, as I said before that, if you want to go for post grant oppositions, any person can apply, any natural person. Even I can apply for you. Okay, I can help you. Okay, if somebody done your work and they got patent after work, I can go for post grant oppositions within 12 months from the date of publication of the grant of patent. So very important. So after 12 months, you cannot do anything. Okay, so within 12 months, you can approach through the form of post grant oppositions. Any person, you can make use of patent attorney, you can make use of lawyer, you can make use of any natural person or any person. Okay, so by using the applications under the section of 25.2, okay, under the section of 25.2, you can approach the controller with respect to the post grant opposition. Okay, so this is a very important thing. Okay, so this is my particular talk today. So just now, I mean, we have covered all those things, right? Basically, what is patent? What are the patent aspect? Okay, what are the criteria to be done for patent in evaluations? Okay, all those things are done, and also some of the important form also we have done. Okay, so these are the very important. And when you come across like understanding the patent draft, okay, it has some. It is like it's like art. Okay, how we are going to art of our invention. I said right, my inventions is on my brain. I want convert from the brain into document. So these are the contents are very important. Okay, so these are title of inventions. Okay, so these are the subject matter of invention, like background of our patent, prior art, object of invention, which basically meaning that objectives. What are the objectives of invention? And the statement of inventions, and summary of the inventions, and descriptions accompanied by the drawing. So drawing is very important for patent drafting, right? Drawing. And finally, detailed, I mean, depth discussion, tight discussion about invention. So these are very important role, because normally the controller make use of this kind of subtopic only. So immediately once patent draft, right, the controller may be seeing the title of the invention, then they go for objectives, then go for title, I mean detailed inventions. Then after that the claim. So claim, it's a very important role. I'm telling you what do you mean by the claim. Okay, finally you can abstract. Once the claim is done, you can do automatically abstract. So here abstract is different, like unlike scientific journal. Okay, so publication journal is different, publication patent is different. So there are different things are there between the patent and the scientific journal. Okay, so here abstract, don't think that it is like scientific abstract. It's not like that. Okay, so one can derive the abstract from the claim. I'm telling you. Okay, I'm telling you in the coming slide. In this slide, see, you can see the background of inventions, right, and the prior art details. I said already that you go to address the background of the invention, whether the invention belongs to communication field, whether the invention belongs to the chemistry field, whether the invention belongs to mechanical field, whatever. And also you would tell that, okay, here what problems remain to be solved and other disadvantages faced by the inventor, and the solution along with these disadvantages also. Okay, which means basically advantages and disadvantages of other inventors also to be discussed here. So it's a background. Okay, and when we come across prior art details, right, as I said earlier, right, prior art is like nothing but we will collect some existing document, existing patent from different database. and you have to correlate your invention. Correlate your invention. What are the unique in your project or in your invention? So these are the things you should then when you come across prior details. Okay, then objectives of the invention. Okay, should present our objective of the inventions. At least you should keep at least minimum 2 to 3 objectives. In me, it's enough, or minimum 1 to 2. It's a very important. And when we go for statement of the inventions, it is not mandatory. Okay, after go for objective of the invention, we go for sometime descriptions accompanied by the drawing. Okay, you have to relate your drawing with the pattern. Okay, so this picture, this part explains something. Okay, so according to this machine, this part will be doing something. So we can give some drawing content. So after that, we go for finally in-depth documentation. Okay, so whatever things you should have some experimental data, you have some functional model, advantages, disadvantages, what's happening inside the invention, what will be the outcome of the presentations, I mean your inventions, and what will be income of your invention. Okay, what input is given, what will be getting output, how the process will be giving the response with respect to input output. Totally, okay, totally entire process to be addressed here. It's a very, very important section, and also a very critical section when you're going writing something here. Okay, so you can make some rough draft. Okay, you can do some rough draft. For example, I have done IoT based some machines into field. Okay, I want to go to field, and I want to do sometimes field validation also to be done. It is not mandatory. Sometimes the controller expecting only functional mode only, not physical mode. For that, I don't want to do any demo. I want to do design the instrument. It's not like that. Basically, we should have the functional model in our mind that to be converted into document. For that, the controller may not be asking whether where is your product, show to me, like that. Okay, so this kind of questions may not be arises there. So don't bother about that. But however, if you need experimental based work, okay, you conduct some experimental in laboratory or in field. Okay, collect the output and document. Okay, and get document, and I can apply with them or interact with them. So these and all to be done after examination report. It may be useful for addressing your problem. Okay, addressing your problem with depending upon the queries by them. Okay, so queries may be arises that by the time it will be useful for that. Okay, so I am telling that again. This is a very important section. You should have some in-depth knowledge about it. Okay, in-depth knowledge. Okay, this is another important section. So that is called the claim. So when we talk about the claim, okay, I can go for independent claim and dependent claims. Independent claims and dependent claims. I'm telling that in coming slides. And abstract. Okay, so once you've done the claims, right? Once you've done the claim, I can write the abstract from the claim itself. You don't want to do anything here. Okay, you don't want to touch anything here. Okay, once the claim is written, okay, once the claim is written, we can derive the abstract from the claim itself. Okay, so these are very important tips for you. That is what sections do you write first in patent drafting. So there are two important drafting, right? As we said earlier, that one is provisional and one is complete. Okay, so provisional in sense, we don't want to put any claims on that. Okay, just able to apply with background of the invention, and even sometimes a figure also necessary, but claim is not necessary. But when we go for complete specification, means what your invention going to complete. Your invention going to complete. Okay, so that is exactly what is complete specification. Okay, so somebody may be asked what section we should be write first. Okay, here this is a very important thing, that series TDDA. So see here I can go for claim. Okay, then drawing, then summary, then details of operations, and title abstract. Okay, you would write claim. Okay, so today I'm going something in laboratory. Okay, once find something, okay, try to go for claim. Okay, write something about claim. Okay, I'm telling you, okay, what is claim and all. Then you go for drawing. This is very important. It is already, right? How to draw something, what is a pictures, whether it will be like existing picture or new pictures. Then we go for summary, update all the inventions. Then you can go for in-depth knowledge to be addressed in the detailed discussions. And finally, you can make use of title. Okay, title is a different process. Okay, title. So sometimes title is to be very attractive by the audience. Okay, so accordingly, you got to choose the title. Okay. So this is what I basically claim. This is my pattern, one of the pattern applications. Okay, here it is IoT based physiochemical parameter monitoring system in the mangrove zone. So these are my first claim. Okay, so this is basically independent claim. Okay, so this is the independent claim. I claimed some of the segment are there, like monitoring segment. So this is a numbering is given. Okay, for example, we can give number like 1, 2, 3 for machines. Okay, so soft, for example, numbering 1 given for soft. Okay, number 2 is given for blades like that. Okay, so numbering is given for our invention. Okay, when we come across independent claim. Okay, so here my independent claim is like monitoring segments constitute measure the physical chemical parameter in the mangrove ecosystems. And also it has some transmitting sections which is configured to the transmit set parameter together and central server. Basically, what we do is I'm through the IoT, I'm measuring the data, I mean some input parameters. So that to be transferred to the monitoring segments. Then you can go for server, so, something like that, right? So this is my one of the claim. But when you go for dependent claim, I can derive the another claim. See, listen, I am claiming another claim from the first claim. It means independent claim. So we cannot directly write dependent claim. There is no thing like that. Only independent claim only. So we can derive the claim from the independent claim. Here in independent claim, basically here you can mention like IoT based rate time physiochemical parameter monitoring system in mangrove zone as claimed in claim 1. Okay, from the claimed one in claim 1. Okay, so this is independent, this is a dependent. In dependent claim, what I'm mentioning is that I can measure the parameter in mangrove zone which comprises water level, turbidity, pH, salinity, and dissolved adhesions. Okay, so understand? Okay, in independent claim, I having like monitoring segment, I having like transmitter section, I have the central server. This is to be claimed. I want to get claim for this kind of invention. This is my own invention. I have own server, I have own transmitter section, I have own multi-segment. It's mine. Okay. After independent claim, what we do is we go for dependent claim. What my monitor segment is doing basically. Okay, it is doing like measuring the parameter. Okay, so this is to be dependent claim. So you should have minimum 1 to 2 claim. Okay, minimum 1 to claim. Okay, in complete specification. In provisional means what? Your invention is not completing the process. It's not completed. It to be completed. Okay, because we should have some data, some experimental data, or the experimental wanted to conduct, or are waiting for results, or still results going on. So that to be addressed. So in order to protect our invention early, we can apply your applications for provisional. So this is my important drawing of that. I can mention over all the applicant. Okay, this is the inventor. Okay, applicant. There are two kinds there. One is applicant and inventor. Before inventor may be applicant. You are the inventor. For example, I am working in the Park College Engineering Technology. Park College Engineering Technology is it's an applicant sometime. The applicant and wanted to me to find some invention. So I am the inventor. Okay, I am the inventor. So any natural person may be the inventor. So college may not be inventor, right? College may be applicant only. Okay, inventor are the like natural persons. Wait. Okay, so this is a drawing. Okay, this is a drawing and I giving numbering rate. For example, you can give a according to your convenient. Okay, so it's not any rules like that. You have to give like 100. You can put like 1, 2, 3 also, but I can give like 300 three digits like 109, 110, 111, like that. Okay, 108, 107. This is one of the figures. Having two figures, but for presentation purpose, I'm showing here like first figure only, isn't it? So these are power control, transmission, control processor, interconnected bridge. So these are my part of my invention. Okay, so you should present separately. Okay, your presentations of drawing separate sheet, and abstract also separate page, claim also separate pages. Okay, so this is abstract. See the abstract I said earlier, from the claim I can derive the abstract. So listen here. Here you can listen IoT based real-time physiochemical parameter management system in mangrove zone comprising. This is a transitional. See, this is a consisting of contains comprising. Yes, transitional. It's a connecting the preamble. So this is what we can see preamble. This is a body. So transitionals is connecting the preamble as well as the body of your invention. See, listen. This is a preamble, and this is transitionals, and this is what body of our invention. So these are abstract. Okay, here I mentioned same thing on IoT based real-time physical energy parameter system in mangrove zone comprising a monitoring segment 114 constitute to measure the physiochemical condition parameter in the mangrove zone and level of freshwater measurement in the lagoon and produce the measurement of the data of set parameter. So listen here. Same thing. So what I am saying is, once the claim is ready, I can combine all the claim together to form a abstract. That's it. No need to struggle while writing this abstract. Okay, for that only I am telling you. Okay, somebody may not be understand. Somebody may be in open source it is published. Somebody may be wanted to write. I mean, wanted to read these things, right? May not be understand because it's a format. Okay, so this is a format of Indian Act 1970. It tells us that like this you would write, like this you would draw. Okay, so there are some sections, there are some laws that you should follow. Okay. So to conclude, before conclude, I'm going to show my patent draft also, in which I'm showing how to write it and all. Okay, so we go for to conclude my presentation. The drafting of the patent application play a vital role in the process of protection for an invention. A well-drafted patent specifications which decides the scope of the protections, which will further help in maintenance and management of the patent. Okay, so my suggestion is that once you start thinking a particular thing, so what you do is you have to take a paper and write about your invention, write about your thinking. Keep aside your queries, whether it will be like patentable or not patentable. It comes in your mind. So risk comes. Okay, so don't bother about that. First, start to think about particular invention, particular process, or particular product. Okay, we can modify, no problem. There is a provision here there. There is a provision are there. Okay, accordingly we can compromise the controller. Okay, so this is my conclusions. Okay, so after that, wait, I will show that patent publication and all.
Thank you, sir.
Ma'am, please wait, ma'am. Please wait, ma'am. Thank you, ma'am. Please wait, ma'am. 1 second.
Thank you for your valuable perceptions on this topic.
And so this is my patent, right? This is my patent applications format, right? Okay. They'll be mentioning like that. Okay.
Thank you, sir.
Thanks, ma'am. Thank you. Sincere thank to you.
Thank you, sir. Again. And
yeah, my organization will be giving input for you in future. Okay, you can do anything. So try to